Hey, what's up? It's Stephen A. Williams, president and founder of the creditrepairshop.com. In this video, we're going to talk about validation of debt. We're going to talk about what debt collectors are required to do when they are trying to, well, number one, when they buy debts and they're trying to collect on that debt. A lot of people have asked me, what is the process? Why do they get away with things? Why are they claiming things that that they can't even know because they wasn't the original creditor, what they can and can't get away with? Why are the courts allowing them to also get away with certain things when if you were trying to sue someone, they would make you prove a lot more with that individual? So let's just run through the statute. This is the Fair Debt Collection Practices Act, and this is validation of debt. This is Section 15 USC 169 2G. This is where the validation of debts uh, information is contained. And I want you to wake up, don't fall asleep. I want you to wake up and I want you to pay attention to this because this is where a lot of people end up, I don't want to say like getting into trouble like you're a kid, but where you end up owing a debt or end up where you're having to pay a debt when you could have done some things at the beginning that could stop debt collectors. Now, the first thing, let me talk about your rights. When they send you a letter in the mail, that letter is supposed to tell you who the original creditor was, and it's also going to tell you their information, and you have a right to dispute that debt. Now, you can see here where they had this within notice of debt contents within 5 days after the initial communication with a consumer in connection with collection of any debt, a debt collector shall, unless the following information is contained in the initial communication or the consumer has paid the debt, send the consumer a written notice containing the amount of debt, the name of the creditor to whom the debt is owed, a statement that unless the consumer within 30 days after receipt of the notice disputes the validation of debt or any portion thereof, the debt will be assumed to be valid. This is the one big thing here where I tell people that if you do not respond, they are allowed by law to assume that the debt is valid. Wake up again, wake up. And then number four,
Returning visitor.
statement that the consumer notifies the debt collector in writing within the 30-day period that the debt or any portion thereof is disputed. The debt collector will obtain verification of debt or a copy of a judgment against the consumer, and a copy of such verification or judgment will be mailed to the consumer by the debt collector, and a statement that upon the consumer's written request within the 30-day period, the debt collector will provide the consumer with the name and address of the original creditor if different than the current creditor. So this information right here, uh, it also varies from state to state. Some states the judges are very, uh, you know, strict on not allowing a debt collector to just bring a last statement or anything to court. Because basically, what they're doing is they just say, we want to prove that the account was yours. And they're allowing that. And you can see that's why when you get sued, or if you've ever been sued, that the only thing that they would provide is that they're going to provide a statement. They're not really providing a complete account number or anything, and courts have been letting that pass. Now, technically, by the law, by the way that it's written, and this is why it varies from state to state, is that some jurisdictions will say that that's not enough, that they will make them prove more. That's why you'll have people, even with our clients, where in one state that verification was not good enough, and then in another state that verification was good enough. So it's very confusing because people are like, why am I being treated a certain way? And then another individual is getting a different result. They're being treated a different way when they go in front of the courts or when they ask for verification. And the debt collectors know by the states that they're collecting debt in what is the standard on what is needed to be provided. When we see For example, when we see court summons from California, the debt collectors have to go through a lot of explanation. They have to provide a lot of documentation. They have to go above and beyond to prove even the initial part of saying that the debt is yours and taking you to court. Where in some states, I've seen in some of the southern states, the court summons may only have 3 or 4 lines in their allegation, and they'll have a bank statement, and the court feels that that's sufficient enough. When, on the other hand, in California, I've seen where it was one that I had responded to had 29 or 28 or 29
New
allegations
visitor.
allegations within that had to be responded to. And then they had a whole bunch of documentation, they had a whole bunch of affidavits, they had a chain of command affidavits from when they purchased the debt all the way to I think it was 3 debt collectors that had it in between, and then it to the lawyer that they contracted with in their area to come after them for the debt. So they made them go through a lot more just to be able to file that, when in other states they don't even have to go through all of that. So this is your rights on what you have to do. So now let's talk about the solutions. Number one, if a debt collector calls you and you have not received a letter in the mail notifying you about the debt, the way that the law stands right now, that debt collector has broken the law. So anyone right now, anyone who has had a call from a debt collector, and they'll usually do this because they don't have your correct information, so they're going to try to call and reach out. That's why in some of the when I've done my other videos and I showed where it was Experian batched or it was TransUnion batched, they're doing that because a lot of them have been sued and they want to send the information to the address first, because if they don't and you know about this, or what I'm telling you right now, you would be able to sue them. You would be able to actually sue them. The initial lawsuit that they're trying to come or the initial debt they're trying to come after you would be invalidated, and then you would be able to sue them for $1,000 per violation. So if you have gotten a call from a debt collector and that debt collector did not send you a letter, what you should do is you should reach out to my company and we will see if we can connect you with an attorney in your area to be able to handle that for you. Or worst case, I mean, best another thing is that you could just notify them that they've broken the law, or we can send them a letter on your behalf that they've broken the law by violating that rule that they called you before you received anything in the mail notifying you about the debt. So uh, keep that in your back pocket. So if you ever have a debt collector call you first, that is exactly what you should do. Now, most of them, though, 99.9% of them will do a batch, and they're going to send you that letter in the mail. And it says right here on A here, within 5 days after the initial communication with the consumer in connection with the collection of any debt, a debt collector shall, unless the following information is contained in the initial communication, give you all of that information. They will give you all of that information. So now the next thing that you need to do when you have uh, a debt collector send you that letter, the next step that you need to do is you need to immediately go and check to see if that debt is past the legal statute of limitations to be able to collect, wake up again. Because if it is past the legal statute of limitation to collect, then you have a right and you need to notify them that they are coming after you for a debt. You have no legal obligation to pay that debt. And some of the times they might say that this is a time barred debt. You might even get calls that say that this is a time barred debt. So be very careful. Listen to what they're saying, because some debt collectors have to notify you that the debt is time barred, but people don't know what time barred means. Most people know what statute of limitations mean. They know that there's a limit on when they can come after you for anything with statute of limitations. So uh, immediately go and check the statute of limitations. And you can go to my website,
New visitor.
thecreditrepairshop.com,
Returning visitor.
and you can, on my blog, check the statute of limitations. Type in statute of limitations, it'll take you to a page, and if it's for regular loans that are not revolving, that's going to be in column 1. For revolving type debts, credit card debts, those are going to be in column number 4. And if it's past the legal statute of limitations to collect, all you have to do is notify them that they're attempting to collect a debt that they legally have no right to collect. And don't worry, I'm going to give you that letter to send to them for that below this video. The next thing is, if it is not past the legal statute of limitations to collect, that is not past that date. And just to let you know what that means on that date, it is not when you originally opened up the account, it's from the charge off date of that account. And so if you don't have your credit reports, you need to get that information, because that's where that's going to be contained. You're not looking at the debt collector, you're looking at the original creditor when they charged off the debt, and if it's past that date. If it's not past the legal statute of limitations to collect, then what you need to do is you need to send my cease and desist collection activities letter, which I give you below, and this is going to make them do really what this part here is, where you had that right to dispute the debt, where you're asking them questions. You're asking them if an attorney review. I give you a list of things that you need to ask them, and most debt collectors will not feel that they're going to be able to meet that hurdle of proving everything that you're asking for. They're not even expecting you to know that information. That's why they would most likely choose not to come after you. Now, some of them will, so I'm not saying that they won't. A lot of this depends on what state you live in and how aggressive the debt collector is. So I'm going to give you a third letter, which is another debt validation letter, similar to the cease and desist, but you're just going back and forth, making them prove more information about the debt. And what this will usually do is it'll set up, if they end up moving forward and trying to take you to court, it will set up you in the best position to be able to fight that debt collection, because if they, when you write your summons, number one, you're going to have that letter ready so you can be able to respond. And if they're not getting you information that you're asking for, and you get in front of a judge that will make them get you that information, you can ask for a dismissal, because you've given them plenty of time before they sued. You could, prove to the judge that you did send them that. I had my wake up here. You can send to give the judge and show them the certified letter that you did give them the opportunity to get you the information that you needed, that you requested, and that they just kept pushing it off, and now they have you in court and they're still asking for more time. So you'll be able to get that dismissed because of that. So, and also when you send the information dealing with the debt collectors, you do need to send it certified mail, so you can have proof that they did receive it, because they might try to pretend like they didn't receive it. When you're doing that and you're making those steps, more than likely you're going to be able to have success with dealing with debt collectors, because they don't expect you to know this information. All right, so I'm going to end the video here. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different. This is displays my 8-point validation process, and this is the way that we repair credit with my company. If you need your credit reports and scores, go to the website www.your3scores.com. And then again, we have other services that we do provide. The links are below this video. If you haven't subscribed to the channel, make sure that you subscribe. Make sure you ask your questions and comments. And thank you, and until next time.